Okay, ladies and gentlemen, we're going to start. So my name is Zarin Hainsworth, and I'm the chair of the UK Civil Society Women's Alliance. And this is an umbrella organisation for all the organisations working for women and girls in the UK who are using UN mechanisms. So it's a fantastic umbrella organisation, about 450, 500 individuals and organisations. So we have an international panel of speakers here, so from India, Australia, North America, the UK, and Nigeria.
Yeah, so Nigeria is joining us online.
Okay, perfect. We think legal literacy is really important. It's fundamental to women's rights because justice is not just knowing that the law exists, but it's being able to access it, and the way to, you have to be educated in order to do that. All right, okay. Sorry.
It's not on, I don't think. There we go.
Is that better at the back? Yeah. Okay, perfect. Do you want me to do it again? No. Oh, fine, thank you. Very good. I think you did hear me a bit then. That's cool. Okay, right. So we're going to cover a range of issues this panel. We're going to be looking at storytelling, education to ensure legal literacy, those who are not included in creation of justice systems, the barriers that people face, the gaps in the system, incentives to try to sort out the legal system, and how law reform and judicial pronouncements can stop regression of rights.
Thank you very much, Chair. I just wanted to interject here because I've asked the Chair to share a story which I first heard her share at a Widows' Rights International event in the House of Lords in the UK at the end of last year. And it was such an empowering story that I just wanted to make sure that you could all hear it today. So to introduce our chair fully, because I think that was a humble introduction, our chair today is Zarin Hainsworth, OBE. She's a powerhouse of women's and girls' rights advocacy. She co-founded the UK Civil Society Women's Alliance in 2011 as part of a whole of UK grassroots movement to set up a mechanism for non-governmental organisations to network and collaborate. The Alliance works with the UK government to ensure positive outcomes at the United Nations Commission on the Status of Women, and coordinates the UK Civil Society and NGO delegation. It enjoys a collaborative working relationship with the UK Government Office for Equality and Opportunity, Women's Equality Division, including here in New York City. This week, we've had many fascinating briefings with the office. So Zarin founded Serene Communications in 1997, a people empowerment social enterprise specialising in helping organisations increase women's empowerment. Serene works with UN agencies, government departments, multinationals, and small charities. Zarin was awarded her OBE for her work on women and equalities, and amongst many roles, Zarin is chair of Widows' Rights International, a company member of UN Women UK, vice president of the NGO Committee on the Status of Women Geneva and the Human Rights Geneva, trustee of Equally Ours, and former chair and director, and current ambassador of NAWO, the National Alliance of Women's Organisations. She is a recognised expert on human rights for women and girls. Zarin has been active in civil society since her early teenage years and has been involved in establishing and developing numerous civil society initiatives. So thank you very much, Zarin, for joining us today.
Thank you, Natalie, for that wonderful bio. That's a bit humbling, really. Okay, so very quickly, because I've got to make sure it's in 8 minutes, as I'm going to be very strict with everybody else. So we were in Arusha in Tanzania in 2010 because my son was on a year of service as a teacher, and he took with some of his students who are actually the same age as him or older, because the Maasai aren't able to take education all in one go, and so they have to take years out in between getting their education. So he was teaching O-levels science O-levels to some students, and some of them were, as I said, his age or older. So we gathered some of them together and we went on a safari because we wanted to go to see the Baha'i temple in Kampala. It was a very fraught episode because our vehicle kept on breaking down, but I'll regale you with that story another time. But there's an organisation in Uganda called Women of Purpose, which WRI had given seed funding to start. So I took one of the Maasai with us to visit this place, and they were blown away by this organisation. It was the first time they'd seen an organisation that was organised by widows or organised by women, and they suddenly saw that there was a sense of agency that women could have themselves. They also were shocked by what the women were saying about polygamy, because some of the women had experienced polygamy, and of course polygamy is something you have in Maasai. And when a man dies, all of his wives are inherited by the rest of the family. So they were shocked to hear what it was like from the women's point of view that only thought about it from their point of view as Maasai warriors. So when we went back to that area, we went to visit each of the villages that these lads were from, these warriors were from, and we spoke to the women there, and we sat down on the ground outside a hut and talked about this organisation, Women of Purpose, and said, would you like something like that here? They said yes. We said, what would you call it? They said Nasarian. Nasarian means the gift of God. And that's why they gave the name Nasarian. So Nasarian started 2010, and we went back. So when we first got it started, we said to them, look, just meet as often as you can and share your stories with each other. And so what happened at the beginning, they were taboo. They thought there was only like a few widows in the village. But as soon as they started meeting, and they decided once a week wasn't enough, or once a month wasn't, they met every single day. And they sat down together and they started sharing their stories. And they found that some women, when they were inherited, it was okay. Their husbands treated them all right. And some of them suffered violence, and some of them had awful experiences. So between them, they started, learning from each other. Then we sent some of them on a course about the Tanzanian constitution. And so there was 30 widows, 2 from the 15 villages where the Nasarian was, who learned about the Tanzanian constitution. And then those widows went into their villages and taught all the village about the Tanzanian constitution. Now you can imagine what this was like, because on the one hand you had this group of women who were invisible, it was taboo, it was bad luck, they hid away, and suddenly they're the ones who are teaching the whole village about their rights under the Tanzanian constitution. So it changed the understanding of the villages about the status of widows, but it also helped them understand about their rights. And so the widows started learning more about the constitution, they went on training for FGM and so on, and as a result of that, when we went back in 2017, we found that there was almost no FGM in any of the villages. Because what had happened is the women had decided they were going to stop FGM. Once they did the training, they went to the women who were doing the cutting, which was the midwives. They showed them that some of the problems that the women were experiencing in childbirth was as a result of cutting. And so therefore, the midwives stopped cutting, trained the other midwives never to cut again. And so what happened is FGM stopped in those areas. They talked to each other about violence, and when somebody was suffering violence, one of the widows, they would all go to the community leaders, and they would help get the community leaders that would stop the violence taking place in the house. So violence against women was absolutely reduced in those areas. Then when they heard, they set up a social and economic project making soap, and they used the proceeds to pay the school fees for girls. And so when they heard about child marriage, they would go to the parents and say to the parents, look, if you don't send your child to be married, we'll pay for the education, we'll pay for the school fees. So that reduced some of the child brides. But sometimes when they heard that this hasn't worked, they went to the wedding and they stopped the wedding. And they said this is not acceptable under Tanzanian law, because they learned about the law from this education they got from each other. So one of the really interesting things about this story is that you can see how when the women started just by talking with each other and sharing each other's stories, they were able then to do something about their understanding of the law and how it was implemented in Tanzania. And I think that's a story that Natalie was very interested in. And that's why we're going to start with it this time. So thanks very much. So now I'm going to do the thing that Natalie just did for me the other way around. Okay, so this is Dr. Natalie Turney, and she's Vice Chair of the UK Civil Society Women's Alliance. She's a lecturer in law at the University of Reading. She's a published author on women's rights, access to justice, corporate insurance, and criminal law. She presents high-profile events on this range of legal issues, including at the Palace of Westminster and at CEDAW's Women's Parliament. She actively engages in national and international policy discussions on women's and girls' access to justice. She is chair of the UK Civil Society Women's Alliance Working Group on Women and Girls Living Under Occupation, which is an interesting idea that came up as a result of last CSW, and the Alliance has created this working group and has moved it forward. So this is something we hope you will all look at, is the idea of women and girls living under occupation that Natalie is moving forwards. And she's also the working group of the CSW70 agreed conclusions. We have a text group that works on the zero draft, and Natalie is the one who's been chairing that. She's attending CSW as a member of the National Council of Women, and she sits on its advisory group. So Natalie is going to be talking about defining legal literacy, community-wide education, and training on legal literacy, which is accessible and contextual. Natalie, the floor is yours.
Thank you very much. Thank you, Chair, and thank you so much, all of you, for joining us for a critical conversation about the impact of legal literacy on women's and girls' access to justice. So we must start by acknowledging that the mere existence and even mere knowledge of formal legal rights and formal justice systems are insufficient to deliver justice to women and girls. Equal and equitable access to justice are underpinned by knowledge and understanding, that's true, but it's the ability and capacity to assert rights meaningfully and to navigate structural mechanisms which can unlock access to justice. So legal literacy represents a spectrum from awareness or consciousness on one side to expertise on the other. And within that spectrum, there are varying levels of competence and skill displayed. We have knowledge, understanding, assertion, the participation, mobilization, sharing knowledge, and more. It's a transformative political and social process essential to women's empowerment. But legal literacy is a privilege. It's entirely out of reach for many, at least while the status quo remains. So if I can just ask for a show of hands, if anyone here has ever heard of the principle, ignorance of the law is no defence, or ignorance of the law is no excuse. Okay, majority of the room have their hands raised. So if this is a basis upon which law and justice is administered, I think we would probably all agree that it's critical that a good level of legal literacy amongst all citizens is achieved. But the question is how? So how do we change the status quo? Well, education is vital in bridging gaps of knowledge and accessibility. And when I say education, I mean in both formal and informal terms. So typically here follows mention of schools. And whilst this is simplistic, we do need to acknowledge the value and the power of meaningful education of the youth at critical junctures in their development about foundational concepts and values. So girls and boys can be taught about their rights, and through a less generalised lens, they can be taught about structural biases that exist against women and girls and upholding their rights and their access to education. But school education on this is, of course, not enough. Access to all women and girls is critical. So those in rural areas, in particular, are persistently confronted by the legacies and continuums of patriarchal systems, which so often oppress their rights and access to justice. So legal literacy as an educational pursuit requires adaptation to shifting contexts. Social, cultural, economic, political circumstances, they all need to be meaningfully considered to ensure accessibility and to avoid disconnects from learners' lived realities. So what does this all mean in practice? Well, of course, there's talk about the use of online tools, and actually Jocelynne, my fellow panellist, and I attended a talk this morning where this was mentioned. So beyond online courses, studies in Bangladesh and Pakistan have demonstrated success in the use of social media in enhancing learning of both legal and financial literacy. But while we can appreciate the positives, we also need to acknowledge that the online world isn't accessible to all women and girls, right? 30% of the world's population is offline. So we can only see this as one of a suite of measures that could be adopted. Other methods outside face-to-face settings, which might reach those who are not online, particularly older women, will include radio, television programs, printed materials, and more. But in the room is often more productive when delivered effectively. And in community outreach programs, so for example, for rural women, educators must appreciate that actually the learner comes with relevant knowledge and experience, wherein the educator's own knowledge and experience can be layered in. So this produces an equal exchange of ideas where both can learn from each other. And it allows a centering of context to legal literacy. Educators will facilitate the development of knowledge and ensure that the learners are actually active in the exchange, so for example through role play. Meeting learners at an equal point is critical. It means understanding local dialect and mannerisms, working with someone who can support if you do not have this insight yourself. It means educators must consider those inherently perceived power differentials between them and learners, because educators as gatekeepers of knowledge can themselves act as rights oppressors and risk further marginalisation of learners when their approaches perpetuate attainability gaps and distrust of the law and justice systems. We need to identify bias in educators and address this through training, because they're not just teaching what the law is, they're teaching why certain laws exist and why certain women or all women face structural oppression. So we need to understand learners' home environments and social contexts. If we take the example of a rural woman, let's say a rural woman who's unable to confront her husband and assert her rights, is the answer to allow men into the same room so that they can be audience members? Well, the reality is if you do that, a woman who faces oppression at home will confront the same if her oppressor is invited to observe her learning how to resist, right? So women's spaces are sacred, and separate programs can address issues in terms of biases and backgrounds of learners. Joint conversation should really come at more advanced stages. It doesn't need to begin with the law. It doesn't always need to begin together. We need to make sure that women are provided with the technical tools and empowered through a range of measures so that we can arm their enhanced knowledge. So, for example, economic independence, enhanced social skills. So I'm going to conclude with 6 action points, but I really hope in the interactive dialogue you can add to my list. How can we make this all happen? Government-led education campaigns, number 1. 2, enhancing the work of NGOs through meaningful funding support. 3, ensuring programs built by and for women with separate programs for men where appropriate, and joint learning only where it's been ascertained for sure that oppression will not be further perpetuated and hard work with women undone. Context-specific initiatives, so for example, specific projects for asylum seekers or migrant workers or for law and justice actors. Using responses received from women and girls during discussions in an empowering way, so for example, by informing petitions for law reform. Encouraging women to see the power in their voices both independently and as a collective, to recognise their strength in allyship together. We need to break the culture of silence amongst women, and the power of communal mobilisation is key in ensuring accountability, as Zarin mentioned, so that we can come as an irrefutable collective, one unified voice, and ensure that culturally rights they are capable of being asserted. So finally, legal literacy is not just knowledge, it's the ability to participate. Gender-responsive legal literacy education is critical to unlocking access to justice. Thank you.
Perfect time. Wonderful, perfect timing there. Now we're going to have our next panelist, which is Dr. Heena Sinha Cheung. Correct, okay. She's an Indian-Australian social impact entrepreneur, a governance advocate, and founder of My Safe Circle. It's a not-for-profit advancing child safety and survivor-informed systems reform. She's Vice President of the Communities Council on Ethnic Issues in Australia and works at the intersection of legal literacy, structural accountability, and multicultural community engagement. She's a survivor of childhood sexual abuse and integrates her lived experience with governance practice to advocate for reforms that centre those historically excluded from justice systems, including First Nations communities. Her work focuses on prevention, culturally responsive accountability, and strengthening institutional trust. She's an author of My Safe Circle, Learning to Protect Ourselves. It's a picture book for children. And she attends CSW as a delegate at the Temple of Understanding. And Heena's going to share some thoughts on legal literacy for all that focus really on making sure that those who are seldom heard are heard, so for example First Nations, and also driving survivor-informed governance and structural reform. Heena, the floor is yours.
Thank you. Thank you, Madam Chair. So when we speak about legal literacy, we often describe it as knowledge, understanding rights, laws, and legal processes. But for many communities around the world, the challenge is not simply whether people know the law. The deeper question here is that were the systems of justice ever designed with them in mind? Because for many communities, particularly First Nations peoples, survivors of abuse, and historically marginalized groups, justice systems can feel distant, intimidating, and at times deeply mistrusted. I speak about this not only as someone working on governance reform, but also as a survivor of childhood sexual abuse, someone who has experienced firsthand how difficult it can be to navigate systems that were never designed with survivors in mind. So today, I want to suggest something slightly different. Legal literacy is not only about informing people of their rights. It is also about asking whether the system itself is worthy of their trust. And that distinction matters. As I prepared for this panel, I had the opportunity to speak to Uncle Shane, who is a respected First Nations leader in Australia, about the gap between the law and lived reality. One thing he said stayed with me. He shared that communities often raise the same concerns, attend the same consultations, and share the same truths about their experiences with the justice system. And yet, in his own words, nothing changes. That is not simply a literacy gap. It is an accountability gap, a design gap, and ultimately a leadership gap. Because when communities continue to tell us that systems are failing them and those systems remain unchanged, we must ask deeper questions about how is justice structured. In Australia, Aboriginal and Torres Strait Islander people make up around 3% of the population, yet more than 30% of the prison population. Statistics like this force us to confront a difficult truth. This is not simply an individual behavior. It is about system design. Uncle Shane spoke about how many First Nations families grow up with experiences of law enforcement shaped by intergenerational trauma, mistrust, and unequal treatment. For some communities, the justice system has historically represented surveillance rather than safety. And when that history exists, simply telling people to understand their rights is not enough. Because knowledge without access is not justice, and knowledge without safety is not justice either. This is why we must expand how we think about legal literacy. Legal literacy cannot be limited to teaching individuals the language of law. It must also involve understanding how systems operate, who they serve, and where power sits within these systems. And importantly, institutions themselves must learn from communities they claim to protect. Justice is not strengthened when systems speak about communities. Justice is strengthened when systems are built with communities. This is where I believe that survivor-informed governance becomes critical. Survivors often encounter systems at their most fragile moments when harm has already occurred. And in those moments, survivors see very clearly where systems succeed and where they fail. We see when procedures exist, but compassion does not. We see when institutions protect their reputations rather than the people they are meant to serve. And we also see how easily people become lost within these processes that were never designed with their lived experiences in mind. It should, according to me, lived experience should not be treated as symbolic consultation. Lived experience should be treated as an expertise. Expertise that helps shapes policies, governance, and structural reforms that are more responsive and more just. Reflecting on Uncle Shane's words again, something that captures the challenge which many communities face, he said that we are only working with the part of the problem. And this insight resonates globally with various communities, because when we focus only on legal processes without addressing the broader realities surrounding it, reform remains incomplete. And if we educate people about their rights but ignore structural barriers such as racism, mistrust, or cultural exclusion, we are only addressing part of the problem. If we respond after harm occurs but fail to invest in prevention and community trust, again, we are only working with the part of the problem. And if we consult communities without sharing power in decision making, we are still only addressing part of the problem. So what does meaningful progress look like? Firstly, legal literacy must begin early. Children and young people should understand their rights, their safety, their dignity, and how systems work. Education about law, safety, and accountability should not begin when someone enters the justice system. It should begin long before the harm occurs. But knowledge must also be paired with pathways. Pathways away from violence, pathways away from incarceration, and pathways towards belonging, opportunity, and community support. Second, justice systems must move from consultation to co-design. Communities must be involved not only in identifying the problems, but in designing solutions. Across Australia, we have seen several examples of community-led justice initiatives, diversion programs, and culturally informed approaches that bring elders, families, and communities into the justice process. These approaches recognize something powerful. Justice is more effective when it reflects the values, culture, and lived realities of the people it serves. At international forums like this, we often speak about empowerment. But empowerment is not only about providing information. Empowerment means ensuring people can act on the knowledge within the systems that recognize their dignity. Justice must be something every community can recognize as their own. And when legal literacy is combined with structural reform, survivor-informed governance, and genuine community partnership, we move closer to the goal. And conversations like today matter the most. Thank you.
Thank you so much. Thank you so much. Wonderful to keeping to time as well. Great. So at this point, we would have had Wandoo, and I can't pronounce her name properly, Aibangbee? Thank you so much. Well done. Very good. Who's a Nigerian registered barrister and doctoral student at the University of Buckingham. She's researching the custodial rights of widows in southeastern Nigeria and the intersecting influence of statutory, customary, and religious law. She has vast experience in the microfinance sector and is distinguished by her strategic initiatives that leverage corporate governance and legal frameworks to create opportunities to champion financial inclusion for vulnerable women. She's also a contributing author to Women, Power and Autonomy, Rights, Respect and Representation in Law and Society, and she's also a member of the CEDAW Women's Parliament. She would have been here with the International Alliance of Women, but unfortunately the current visa situation is that her visa was not accepted. But if you look in the programme, which you all have on your places, and use a QR code, you'll be able to find her video on there. And in the recording of this event, we will include that in as part of the programme.
Hello everyone, thank you for joining us today. Today I will be speaking on access to justice from a Nigerian perspective. My focus will be on gender-based violence. As we all know, access to justice is a foundational element of the rule of law and a prerequisite for the realization of human rights. It is not just about the courts and the legal frameworks countries have. It is about individuals being able to seek, to obtain, and to enforce remedies without discrimination of whatever form. For the Nigerian woman, access to justice has indeed improved in the last decade through legislative reforms, such as the Violence Against Persons Prohibition Act of 2015 and institutional initiatives such as that of the Nigerian Human Rights Commission, the Joint Committee on Access to Justice in 2005. However, it remains hindered by continued gender-based violence, Nigeria's legal system, Nigeria's plural legal system, economic dependency, socio-cultural norms, and systematic institutional weaknesses. Let's look at the empirical figures. The Minister of Women Affairs has reported that there are about 30,000 gender-based violence cases in Nigeria between 2020 and 2024. In 2025 alone, there were 10,000 cases, yet only a small fraction of these numbers of women received support. Furthermore, the Nigerian police force stated that it recorded no fewer than 17,415 cases of gender-based violence and domestic-based violence in 2024. Out of that number, 15,692 were charged to court, which is indeed commendable. However, only 409 convictions were secured. Despite these numbers, most of the gender and domestic case violence remain unreported. Now, the real question is, why do they remain unreported? Let's look at the limitations. Nigeria's plural legal system. Access to justice when customary and religious norms are applied in ways that conflict with constitutional guarantees, creating uncertainty, inconsistency, protections, and barriers to women seeking remedies in formal courts. For example, the Child Rights Act sets the minimum age for marriage at 18. Due to incomplete domestication in some Nigerian states, child marriage still prevails, and these girls cannot challenge such unions. You also look at the domestic violence cases. Community or religious forums may prefer reconciliation over formal reporting or persecution, despite the ability and the Violence Against Persons Prohibition Act recommending people to report such cases. This restricts women's effective access to justice. You look at the economic inequality that restricts access to justice as well. Due to the high cost of legal representation, court filing fees, transportation to and from the venue, the time away from possible income which these women are earning, and then childcare. This makes it impossible for many women to initiate and sustain legal claims, which most of the time take so long due to prolonged adjournments, slow investigations. These delays are largely due to procedural adjournments, service of process challenges, and then weak enforcement mechanisms, significantly affecting women's practical access to justice. Not only just to justice, to timely justice. Then in African countries, patriarchy is a strong force, and this directly undermines cases of justice by discouraging women and girls from reporting violations or going forth to pursue legal remedies. This is because they fear stigmatization from family, from friends, and from the society in general, therefore limiting their access to justice. Collectively, these factors create a justice system that is formally available, but substantially inaccessible to many women and girls. So let's talk about the recommendations. It is believed, and I strongly believe, that effective and inclusive justice is possible and requires a determined, holistic, and multi-level strategy, which is not limited to what I will recommend. We need to harmonize the institutional efficiency, such as the courts, the correctional services, and the police force. They make sure they work together so that once people are meant to be brought to court, they are brought to court at the time and the day so that justice is dispensed quickly and immediately. Strengthening institutions through specialized trainings, ensuring adequate funding and accountability mechanisms to provide responsive, timely justice. Economic empowerment of women through microfinance schemes, loans, SME schemes, and grants. At this point, I would like to state and give credit to one of the national institutions in Nigeria called the National Microfinance Bank, which has consistently and deliberately helped women across the country in their finances. It is also important that we sustain the education of the girl child, not just education. They must remain in school, enrollment, and being retained. It's one thing to enroll and not being retained. Our children must go to school. Our girls must understand what is out there, the laws, their rights, and how it will be beneficial to them as women and to the entire community. Ultimately, the sustained political will of every government is essential to dismantle these barriers. In conclusion, I would say, Nigeria has done well. Credit must be given for the progress made for access to justice in Nigeria. However, Nigeria remains deeply constrained and requires a sustained transformative reform. Thank you.
So now we turn to Gisèle. So Dr. Gisèle Yasmeen is a Canadian and has worked all over Canada, as well as abroad, particularly in Asia. She is a J.W. McConnell Professor of Practice at the Maxwell School of Public Policy at McGill University, and has held a number of leadership positions in research, higher education, and public policy for more than 30 years. She's on the International Advisory Council of the Centre for Open Societal Systems, and has advised international clients, including the Asia Pacific Foundation of Canada, the Food and Agriculture Organization of the UN, and the World Bank. Gisèle's expertise is on basic needs, particularly food, livelihoods, and housing, and she's a fierce advocate for women and girls. She attends CSW as a delegate, a member of the National Council of Women of Canada. So she's going to be telling us about gaps in the system and incentives to pursue settlement and non-disclosure agreements rather than restorative justice. So please, Gisèle, the floor is yours.
Thank you very much. Is this on, this one? There we go. Thank you, Madam Chair. I'd like to start also by situating myself, not just where I'm coming from in this presentation, but geographically. And even though I've been to New York many times, I finally educated myself a bit before this presentation and want to acknowledge that the Lenape people, also known as the La Perhoking people, are the traditional custodians of this land and were forcibly displaced in what was called Manhattan. I always wondered where the word Manhattan came from. So they had their legal traditions as well, and for those who still survive have continued those traditions and are reviving them. I'm also not a lawyer, unlike some of my fellow panelists. I'm a user of the legal system for my own purposes and facets of my life. And as Zarin mentioned, I've worked on food and food systems where the right to food has been certainly something that has shaped my perspective, my scholarship and activism. I think we've already established in this panel that literacy, legal literacy is an essential life skill. It should be considered a basic competency. Women in particular are vulnerable without this knowledge, but that furthermore, we need access to resources to defend ourselves, to get the best advice in cases of either civil or criminal matters, whether it's a domestic matter, a workplace issue, or in a broader societal setting. And just to give you a bit of context, beyond the many indigenous legal traditions that existed before Canada was created, we now have common law, but we also have civil law in Quebec at the provincial level. So I'm speaking here also as a member of the National Council of Women of Canada delegation. So I do want to cite an important resolution of the NCWC, which was passed in 1990, probably in need of a bit of an update, but did speak to, or does speak to, gender equality in the courts, even though my presentation will focus on gaps in the system. And so I want to just summarize that resolution so that you have a bit of context on what the council has done. It was based on the National Association of Women in the Law reports that are issued every year. There have been a number of reports published since that time, and it was predicated on the observation that women in the legal profession experienced and continue to experience discrimination and don't have reasonable accommodations. We all know the stereotype of women lawyers in the private sector giving birth on a Friday and being back in the office on the Monday. I don't know how that's even possible. Lack of female representation in the judiciary, government boards, committees. And there were resolutions to urge the Government of Canada to mandate the provinces and territories to continue to investigate gender discrimination in the legal system, to resolve to have jurisdictions provide education on gender equality for judges, law students, law professors, and lawyers, and to reiterate the 1980 resolution to appoint women in proportionate numbers to federal decision-making bodies. But my question is, and really this is, to provoke a discussion, is it enough to add women and stir and address specific issues within the existing system? Or do we need to restructure the system itself, or both? And as the chair mentioned, I want to focus on these gaps in the system. And there are a number of, I've been told that our legal system is based on, a commercial interests, right? It's about money. And there's so much pressure to push things under the carpet, sign a non-disclosure agreement, for example, right? Hush money. I've heard the whistleblower activists say that should not even be legal when there are public funds involved. When you sign an NDA, you can't tell your story, and there may be a public interest concern that needs to be aired out. Canada is starting to bring in Indigenous-inspired restorative justice approaches, and I want to give one example, actually from my family, without naming an individual, but a younger person who had been physically assaulted by other young people, and we could have pressed charges. It was a criminal matter, but they came to us and said, look, there's an alternative here. It's a young person, they'll end up with something on their criminal record, but you can explore restorative justice approaches, and if you're not satisfied, you can still press charges. And the matter was resolved that way. And of course, there's an incentive to not have a criminal record. So in civil cases, it may not be as well developed. But throughout various provinces of Canada, this is starting to emerge. And again, it's been the First Nations, Métis, Inuit influence. And I think there's something there that we need to develop, just like the Ubuntu concept from South Africa, because our system is very confrontational. Right? It's a bit like our elected officials fighting each other across the aisle. So do we need different, more restorative type approaches, Indigenous dispute resolution mechanisms, things that we can learn? And what are the gaps in terms of the areas that are looked at? Domestic abuse, it seems to be further along than workplace abuse, for example. And so there are many social scholars and activists working to try to fill those gaps. I want to end also by flagging the great work that's done by colleagues in a number of areas. We have colleagues from Nova Scotia here who were just on a panel earlier on non-state torture. Thank you very much for your work. And then a colleague from Portugal as well. You know, actually having the language to say that what you went through was criminal and that it was torture, even though it wasn't perpetrated by a state actor. I mean, that is empowering, right, for change within the system. I also want to flag the work of the Women's Legal Education and Action Fund, also known as LEAF in Canada, which raises awareness and resources, because often women in particular don't have the financial resources of men and aren't able to access both the knowledge and the representation that's required. So I want to, just really conclude by saluting all of those efforts. This is not my core area, but one that I want to contribute to, and look forward to our Q&A and discussion. Thank you.
Thank you so much. Again, I applaud you for your timekeeping. You know, one of the things that occurred at CSW some years ago is that Indigenous women was the emerging issue. And for me, this was one of the most important CSWs I've been to in the last 26 years, because the first time I came was in 2000. And that's because they completely changed the discussion. First of all, they always started with this recognition of our ancestors and who had the land originally. And then they also recognized our descendants and those who would follow. And there was this wonderful connection between us and the land, and this sense of history and, togetherness. And the other thing they do is they question the status quo, absolutely. They question the economic systems. They just didn't accept the way it was. And it was so insightful and so inspiring. And the feeling from that CSW continued for a couple of years, and then we've lost it again. And I really hope that we have Indigenous women as a subject for CSW in the future. This year they didn't have an emerging issue. They called it a focus issue, and the focus issue was older women. And I think next year we should push for the focus issue being Indigenous women again, because they bring something wonderful to the discussion, really questioning things. And we were in Canada recently, and the best museum that we went to, my husband and I got really fed up of all the museums. It was the one about the National Historical Museum of Canada, because the bottom floor was created by the First Peoples. And it's so interesting because you go on that floor and they talk about the situation before the visitors came. And on the top floor, you have the history from the white person's point of view, and it's only about what happened from the 1700s or whatever, and nothing like the Indigenous people didn't exist at all. And there was this huge cultural, society and civilization there. So it was, I thank you so much for referring to the peoples of Manhattan. That's wonderful. Thank you very much. So we're going to move on to Jocelynne. The Honourable Dr. Jocelynne Scutt is an Australian, currently based in the UK. She's a barrister and human rights lawyer, registered at the Bar of England and Wales with Fraser Chambers, and also at the Victorian Bar. She was the first Anti-Discrimination Commissioner of Tasmania, and served as a judge in the High Court and of a Court of Appeal in Fiji. She's undertaken extensive pro bono work. She's president of the CEDAW's People Tribunal 2020, judge of the CEDAW People's Tribunal 2021, and chair and founder of the CEDAW Women's Parliament. She taught law at the University of Buckingham between 2014 and 2024, and is a prolific author on the rights of women and girls. And she attends CSW as a delegate of the National Council of Women of Great Britain. And I love the way Jocelynne frames and gives her questions. I learn every time you do it. So Jocelynne, the floor is yours.
Thank you. Thank you so much, Zarin. Thank you. First, know the law. Second, access the law. Third, make the law. And fourth, make the law work. Now, if we are to make the law and make the law work, first, we have to have real clarity about whether the law as it exists is fine or whether it needs reform. And I want to give you 2 examples where a mistake has been made by women, by us. Intervention orders or protection orders. In the 1980s, this became the issue. Where a woman was being beaten or abused within the home, the answer was going to be introduce intervention orders so she can go to the police and get an order to stop the husband doing it. I want somebody to do a PhD thesis on the women who were killed where the person who kills them has an intervention order against him as well as being out on bail. And you will find so many of the cases where women are killed by a partner or a past partner, that's exactly the case, out on bail and or an intervention order, usually an intervention order. Why was it wrong? Because we let the police off the hook, we let the courts off the hook, because what had to be looked at was the crime that was being committed against the woman on which the intervention order is based. Now, intervention orders are civil law, not criminal law, but let me come back to this issue. A woman will not go to the police the first time the husband raises his fist to her. When she goes to the police, it's because she is afraid she is going to be killed. And leading up to that, there will be a number of crimes. And when the intervention order is issued, if it is, because she's never going to get it if she goes to the police first, the first time she's hit, there has to be this series. And so the intervention order puts under the carpet every single crime that is being committed against her in the lead up to getting the order. And if she survives, if she's not killed, then if the intervention order is breached and she's still alive, the issue there is not that a crime is being committed against her, it's an insult to the court because it is a breach of a court order. We went wrong. I knew we were going wrong, I have to say that. Second thing, closed courts. Women often advocate closed courts, but no, 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 no. We do not need closed courts. There's no notion that the woman will be in court giving evidence in a vacuum. There will be a judge, there will be a tipstaff, there will be a clerk to the judge or an associate to the judge. There will be 12 members of the jury. You've got 15 people already in the courtroom. There will be a courtroom attendant, 16. There will be 2 barristers on either side, 20. There will be 2 solicitors on either side too. You've got 24. And who don't you have there? You do not have there those who should be there supporting that woman. And if you're anti the press, don't ever be anti the press in those circumstances. If the press comes out with a story that the defence counsel was saying the woman was wearing a red, red underwear, which had happened in Ireland, and a member of the parliament held up one of these pieces of underwear to show exactly. Well, of course, you don't want your underwear to be shown in the parliament or in the media. But the point is, the media is our friend because we know then that the wrong questions are being asked by defence counsel. That piece of underwear is completely irrelevant. It should never ever be raised, and the media will tell us if it's being raised. We do not want closed courts. Number 2, the undermining of changes. Provocation law meant that if a husband came home and found his wife in bed with another man, he could kill them both, strangle them, knife them in the neck, etc. And that was got rid of in many jurisdictions. In the United Kingdom, what replaces it is loss of control. And in the loss of control, there has to be a triggering element. And the law specifically rules out allegations of adultery, allegations of sexual misbehaviour, so-called, on the part of the wife. In the Clinton case, that has been totally undermined. The trial went forward, it was a woman judge, and she ruled out loss of control, because the loss of control involved the man being told by the wife, allegedly, she's dead now, we don't know, you will have to look after the children, that she laughed because he'd been looking up how to commit suicide online, and that there was an allegation of adultery, infidelity. The judge ruled out loss of control. When it went on appeal, the judges brought back provocation effectively, because what they said is, what the law says is you can't take into account infidelity, but that's if there's nothing associated with it, which is not what the intention was at all, and it's clear from the Hansard. But they said, oh well, she laughed at him about looking up for suicide, and she said he had to look after the children. Therefore, infidelity is back in. So they've completely undermined that law change. And if you think about it, it's ridiculous. The only way that a jury will ever say that there is loss of control on any basis, it will be because of the allegation of infidelity if they find it. It's not going to be because she laughed at him about suicide, or that she said, you better look after the children, I'm not going to do it anymore. And the third one is distortion of the law. There's an old case, Yerke and Jones, where it was actually not economic abuse and coercive control was actually recognised by the House of Lords years ago. It's almost 100 years ago. And what they said is that because of the marital relation, now that it was at a stage where we actually were allowed to own our own property in marriage, we're allowed to keep ownership of it. And what they said is that if the wife hands over the house, say, to the husband and gives it to him totally, we have to look at the marital relationship and the coercive element that is inherent in the marital relationship, and that therefore we will take away the turning over of the house to the husband and give it back to the wife. Now, how this has been distorted, it's an Australian High Court case, Luth and Diprose, where the man, they weren't even married, and the man handed over a house to a woman about whom he had passionate feelings. And when it went to the High Court said, oh, we need to look at this relationship because, of course, this man is beholden to the woman. And when he handed it over to her, there was a power dynamic here, and he was subject to the power dynamic of the woman. So what they've done is use Yerke and Jones, completely ignoring that that's about the marital relationship and the recognition that women in marriage are in an entirely different position from men in marriage. There was a fourth one, but I will go to my summation. I want to say this. Access to law, access to justice, access to just laws. Every one of us is denied, and every one of us is entitled. Every one of us is demanding. And that means ultimately that every one of us will succeed in changing the way the world is, creating by every day we stand up, we do not stand by every word we speak, creating a world for women to live with safety, security, peace, and hope, happiness and joy. Now just imagine, legal literacy is going to get us this wonderful world, but it is real, it is possible, and we are right to fight for it. Thank you.
So I hope you will note that actually, in terms of our programme, we are not only on time, we are early. So please, we should be really grateful to all of our speakers for giving wonderful insights, but at the same time being really kind to us. I think one of the things we find at CSW is that we listen a lot, do not. We are spoken at a lot. And what we wanted to make sure we do in this panel is make sure that we have time for all of you and to recognise the expertise in the room. So now we're going to open up for thoughts and questions. So we'll take a few at a time, I think, and then we'll see how we go. So does anybody have either a comment or a question, a comment about what they've heard or a question to the panel? Don't all jump up at once. Yes, Hannah.
I just want to say it was a brilliant talk for all of you, and I thank you all for such insight. I I don't have any question for now, but I just want to say it was incredibly interesting, and I've taken a lot from this. Thank you.
Okay, thank you. Please, please can you say your name and organisation?
Hi, thank you so much for this panel. My name is Lori Mortensen, and I represent LDS Charities, and I'm on NGO CSW New York. I wanted to ask a question of Dr. Is it Cheung? Yeah. Dr. Cheung. As a mother of 4 daughters, ages 20 to 8 years old, I was very interested in both the fact that you've written a children's book about safe spaces and about the idea of educating early. Can you elaborate a little bit more on that? And how do we educate without planting ideas of fear, if that makes sense?
Thank you so much. And this is really a great question because I was hoping somebody asked about the children's storybook. There are ways of how we can teach children early on about their boundaries, you know, what is a good touch, what is a bad touch. But often in many cultures and in many homes, this is the confusion, that how do we put that information, give that information without scaring the kids. So my children's storybook, My Safe Circle, actually targets on kids from the age of 4 years to 10 years old, and has stories which does not have graphic imagery around body structures or things which can make them feel uncomfortable. It actually builds their vocabulary and understanding around first having a safe circle of safe adults who they can reach out to if something doesn't feel right, and explaining it to them in a very child-friendly way, that what is a healthy boundary? What is a secret? Do you keep secrets? What's a okay secret? What's a not okay secret? And also making them understand through these picture stories that you can say no to somebody even if you know that person. Because currently in Australia, 1 in 4 children are sexually abused at least once in their lifetime. And if we do not teach our children early on in their life, they will not have the vocabulary, they will not have the tools. And that's why the picture storybook addresses this in a child-friendly way without graphic imagery, and gives them the tools to protect themselves, and also share with their friends when they come to them and say, somebody patted me on the back and I did not like it. I don't like to hug that uncle. It's okay to say no. So putting those concepts in kids from early on will give them the tools to prevent abuse, and even if it occurs, to stop it when it's happening and reach out to the safe adult who they have identified very early on, since the time they were 3 or 4 years old.
I think on this panel we're all kind of educators, and I think it's a really important discussion. I just wondered if anybody else has any thoughts on this issue. So
I think I just wanted to draw on a comment that Gisèle made actually earlier in her speech, which I think brings these 2 answers together quite nicely, and it's about having the right language. And I think you were spot on when you said that. It's about having the right language to be able to access justice in whatever form that is. So we're talking more so here about legal literacy, so legal justice systems. But that's where education in all forms is critical from the early stages. So it may well be in schools. It may well be that perhaps it's not school-led. It may be within communities, and that might be more appropriate. But I think that I just wanted to highlight that comment made by Gisèle.
Yasmeen and then Hannah, please. You have to speak up because that's, yeah.
Thank you so much to everyone. My name's Yasmeen. I'm here with Nawe. Thank you so much for everything that you said. It kind of brought to mind for me when I was at uni in my Freshers Week. I remember that as part of one of the Freshers events, we were given information as a cohort about sexual assault and rape services that were available both within the university and just generally. And I remember that there was some backlash, like internally within the university, for having done that, and that they said that at that time that they had framed the young men in the room as potential perpetrators, and that was unfair, and that shouldn't have happened. And so I wanted to ask whether you have come across that mindset within the legal system, whether you've come across that mindset around raising awareness around legal literacy with regard to women's rights and women's access to services that are available to them in particular.
Thank you. Hannah, please.
Hi, thank you very much. I'm Hannah Musavi. I'm part of UK Civil Society Women's Alliance SEC. My main question is, it's on this, but it diverts slightly. With the development of AI and people's access to understanding what rights and, you know, the legal literacy in a kind of skewed way, what do you think will come from this? Basically, I was thinking how during COVID, when we were completely isolated from everyone, when we went back into society, I remember feeling really uncomfortable. And I'm a very confident person, happy to be engaged with every single kind of a person. But I was really uncomfortable. And suddenly, even the dynamics in society, I was uncomfortable with a lot of men that were just suddenly around. And in these changes in society, with AI, with technology taking over, would have less access towards people. What do you think will happen on both of these sides of technology advancement?
Thank you. So let's hear from Gisèle first, please. What are your thoughts?
There's just, I don't know what is going to happen. This is a civilizational change. The only story that comes to mind for me is I have a friend who grew up in East Germany before the Berlin Wall fell. He won't do any social media whatsoever. He doesn't even have a credit card. He has an email. That's it, because he grew up with the government listening in on the phone. So there's also our own kind of, we're putting everything online, our birthdays, our everything, photos of our kids. So what adaptation do we need in our own daily habits? We're trusting, right? We do. On the one hand, we're paranoid, On the other hand, we're trusting. But I keep thinking of, I know this is a bit unrelated to your question, Gisèle Perico. I mean, I'm proud to bear her name, her first name, who, trusted her husband for 50 years. She was happy. She had children. She had no idea. And the police found out what was happening, and she decided to go public, right? Because there's shame associated with this. And so I'm just overwhelmed, really. I mean, I worry for my kid. Thank God I grew up before social media, because there'd be things out there that I might not want out there. And caution, we need to exercise a lot of caution. Love to hear from the other panelists.
There's a wonderful book called Nattering on the Net by Dale Spender, and it was published at the end of the last century, around about 2000, it might have been 2002. And in that book, she's looking at Google and the way that it's being programmed. And of course, it's not being programmed by us. It's being programmed by men who are the programmers and who put the data in. And so if you go onto Google, you'll find much more that's written by men than you'll ever find that's written by women. Wikipedia is full of men. There's a group in Australia that's determined to get women's biographies onto Wikipedia, and they're working really hard at it. But the problem with AI is that the same thing is going to happen. And there was another book by Anne Gaiman and Rosemary Pringle, which was written in the 1980s about the computer industry, and saying this is a new industry and women and men should be equally represented in it. Well, of course, we weren't. And I think that the patriarchy and the way that the world is organised is so strong. Every battle we have to actually overcome it is a real struggle and a real battle, and every time we win, it's magnificent. But I think however good the web is, and we know it's wonderful in so many ways, it's infiltrated with the world that we live in. And I think that prospects for AI don't augur all that well. And the final point I'll make about it is that people are using AI, I'm sure you know this, in the legal system, and they're coming up with submissions that have got case references in them that are hallucinations. And so it's happening in the US, it's happening it's happening in the United Kingdom, it's happening in Canada, Australia. And initially the judges would say you fined $8,000, and now they're making complaints to the legal organisations, to the legal regulatory organisations and so on. But it makes things up. And the final point, sorry, I will make about this was I'd actually looked on AI because I was writing about a case in which I'd been involved, and I forgot what the names of the departments were in this particular technical and further education institution. And I asked it, and it came back and said, oh, I don't know what the departments are, but I can tell you what the case was about. It was about sex plus pregnancy. It was a sex plus case. Well, it wasn't about sex plus pregnancy. It was about sex plus ethnicity, race. I know because I told it, and then it expected me to actually help it get it right. And I mean, if that mistake was made, how often is it making mistakes? It does just make it up.
Thank you. Natalie, do you want to say anything?
I'll attempt to address both questions. So, Yasmeen, first of all, I think the point you raise is it's really important because the education is key at every stage. So you want to be teaching in primary schools, secondary schools, within communities, but university education is also really important. And for some men, it will be the first time that they come into contact with a particular area that they're being educated on. The difficulty is framing men as perpetrators, as you say. You don't want to alienate the men in the room when you're trying to educate them, but the men do need to be conscious about, for example, consent laws and so on, which they just might not have been taught in as much detail. They enter into this new world of university, and the likelihood is that they will be greater exposed to situations whereby they need to check consent and so on. So it pertains to their legal literacy too. It's not just about the legal literacy of protecting the women and girls in the room. It's the legal literacy of the men knowing what are the boundaries that have been set within the law itself. And that's before we even think about morals and ethics and so on. But it is also important to note that the way some laws are constructed, they are constructed in such a way that it is male specific. So when you're talking about particular sexual offences, that does need to be considered too. So hopefully that's answered that question. And then Hannah, just to come on to your point about kind of tech advancements and this just general discomfort around men too. I think one thing that's really important, and I mentioned this in the youth forum on Sunday, so apologies to those who were there. It's so important that the way the law develops in this regard, so with these just faster than we could imagine tech advancements, that it's more proactive than it is reactive. And the trouble is that when we see an area that's so fast moving, the law does tend to react, okay, and it's law reform. I feel that there are mechanisms that could be put in place within legal frameworks to create a more proactive and therefore preventative framework. And that would mean that everyone would feel safer online and offline and would generally then kind of decrease discomfort. When I was at the youth forum, I asked how many people were on social media, and I think everyone raised their hands. And I mentioned the recent Grok scandal with the nudification tools. I asked how many people in the room were concerned that perhaps any photos they might have posted online or photos that may have been taken of them could one day be put through a tool like this. And every person in the room raised their hand except the men, right? So all the women and young girls, and we had young girls in the room too because they were invited to give their critical voice to things. They all had this concern. So we received a briefing, the Alliance yesterday received a briefing from the UK government's Office for Equality and Opportunity, and they mentioned their policy on violence against women and girls, and that this includes online and offline harms. But there's so much more that needs to be done. Really, and I will keep saying this, we need a properly funded justice system. That means properly funded law reforms, properly funded courts. You need to avoid cutting things to try and, there's an argument that, for example, in the UK at the moment, well, if we cut jury trials, then justice will speed up. It won't. It won't. It will actually, for some people, mean justice is not delivered at all. So I think it's about the way that we approach law reform. And I think that we all have a part to play in that. So there will be people in the room who are perhaps more tech-minded than they are law-minded. Contribute those thoughts to any consultations, contact your politicians and so on, because it's really critical.
Thank you. Heena, do you have any comments to the questions?
Thank you. So I just wanted to sort of touch base on the technology advancement side of things and the uncertainty and the fear with the use of AI. In Australia, there are a smaller group of not-for-profits which are coming together and working on creating how do we leverage technology to identify online grooming and perpetrators. So yes, there are online grooming has been happening since the time social media has been there. There has been a change in Australian legislation where kids under the age of 16 years old are banned from social media now. And with the use of AI as well, there has been concerns where AI has been putting suicidal ideation in children, teenagers, adolescents. So there are not-for-profits who are coming together and working together for tools that can be, which are built through AI, but instead of putting these negative elements to the technology, it actually helps in preventing online grooming or prevention of tech-based abuse in women. And the government is investing highly in this area to ensure that we have proper systems to prevent tech-based abuse for all women and girls in Australia. So just wanted to add that.
So just to share, if you have a reflection on what you've heard so far. So Betty, I'm going to go to you first. Have you got a quick reflection on what you've heard today?
I was thinking about how the politics and government say it might be really difficult to regulate social media or put job roles in place where they could monitor and moderate sufficiently. But we see it done in the counter-terrorism world all the time, and they keep on the cusp of new things. So, for example, there are live streaming apps now where you can earn money the longer you live stream to get cryptocurrency. So this is a legitimate, in inverted commas, way of funding prescribed groups, and they are ahead of that. And I know, like New Scotland Yard, for example, at one point were saying violence against women and girls could be a form of terrorism. It's like we need it to have that name just to be regarded so that we can get more funding to go towards it and people will take it seriously.
Thank you. Yes, actually, what happened in 2004 with the Sexual Offences Act is that trafficking was taken out of the normal policing and it was put into the Office of International Organised Crime, and suddenly it had more resources. Susan, do you have any quick reflections on what you've heard so far?
Yep, I was at an interesting event earlier today with the Taiwanese, and they were talking about what they're doing with AI to actually combat the deep fakes and stuff like that. And when we were at the meeting last night with the UK government, they're saying they're working with a group of countries that are trying to do this to block that as a shield. But it was really interesting when they were talking about like the justice kind of side of that, how the silence makes the justice impossible and how we need to speak up more about this. But I just found it really interesting that they had said that with this digital shield, they can take 89% of those images off within the 12 hours of them occurring, and they won't be back on. So there is technology there that's able to do this that would help women get justice for these kind of things. But it was just the thing that stuck with me that was said was about the knowledge. So knowledge without safety is not justice. And I think as long as women feel unsafe and have that fear, they're never going to be able to access that justice. So we need to do more to ensure that we get that.
Thank you. Stefano, would you like to say quick reflections on what you've heard so far?
You got the wrong person with quick reflections. Things to say, but I'll say I love the discussion. Really, thanks for everything you're fighting for. As a man, I'm a father of 4 children, 2 teenage children and 2 toddlers. My wife and I have a straight policy of no social media until they can, be on their own and just they can open it up. My wife and I are extremely careful in sending our kids for even just a sleepover. You have to keep your eyes open. You can't let anything come within, even when you feel in a safe environment. So we're members of a church, right? So we have activities in churches, stuff like that. So you may feel perfectly comfortable in just leaving your children roaming around because people you know and you trust. You cannot allow yourself to do that, and just that violence that kids are constantly, and you don't want to scare them also. So really, I got some very, very incredible insights tonight. Thank you so much for everything.
Thank you. Swati, have you got a quick comment, a quick reflection on what you heard? You have to speak up. That is not amplifying mic, it's mic. So you have to speak. Yeah.
I think it was really insightful, some of the insights that Jocelynne shared about what actually happens in court cases, because we don't have access to that information. We don't as someone who's not engaged with the law very often, it's very hard to know how it actually functions. So it's really helpful that she's shared that with us. And I think in conclusion, it all boils down to money. Whether or not you have the finance to function in these systems, because I think what does tend to happen in UK is that if there are domestic cases, which there are a lot, the Metropolitan Police or the police in general, their basic advice is they're not going to help you provide council housing or help you get a job or to ensure that you have the resources to get out of that situation. So this is where it's quite sad as well that although there is support available, you've got the National Domestic Helpline, you've got the victim support there, you have Samaritans to speak to, but at the same time, if you don't have the money to get out of that situation immediately, because if you do have the money, does it provide you with a lot of options? And if you do have the money, you can pay for the best solicitor to fight for your case or whatever. So yeah, I think it all boils down to that. So yeah, that's my final reflection on that. Thanks.
Thank you very much. So thank you so much, everybody. We're coming to the end of our sessions. So we've been looking at the priority theme, and one of the interesting things I've heard this week is people are questioning the definition of justice and looking at justice in other spaces. So what about justice in sport or justice in health, or the idea that if we want to see justice realized in the world, each of us as an individual has to develop the justice in the way we ourselves behave too. So I think that's been a very interesting conversation, but what I think we've heard today is really to the actual theme of CSW, which is access to justice. And if we want to achieve access to justice, we have to know how to do it. And I think our panel has really given us food for thought in that area in a number of different ways, in a number of different angles. And I really hope that we take that back with us, because we have heard some of the problems of access to justice, but we've also heard some solutions. And I really invite all of you to work with us, with the UK Civil Society Women's Alliance, to take this work forward so that we can work together to make sure that these ideas are shared with others, so that we can truly build a world that Jocelynne mentioned, which is a world where justice is very much that world of peace and prosperity and safety for all of us. So unfortunately, we wouldn't have to have these conversations in the future. And we look back over the last 50 years, and sometimes we can't see much progress, but each of us in this room is a powerhouse for good, and we can all make an effort to make that real. So I'd like to thank our panelists, so Heena and Natalie and Jocelynne and Gisèle, and all of you for coming and for all of your contributions. So thank you very much, everybody. And a very, very particular thanks to Natalie, who is not only the brain but the brawn of this event.